Dun dun. Um, Sorry, had to do it. Welcome, uh, intro to corrections class. This week, week 5. What we're talking about on the syllabus, it says laws regarding corrections. That's part of it, but it's also how corrections are involved with the law. So law and corrections is a better term. I'm sorry if there was any confusion based on the syllabus and the wording of that. It will uh, in the future I'll make that change. But for now, I wanted to at least bring attention to law and corrections. And so, uh, again, today, really what we're focusing on, or maybe not today, but wherever you're watching this, our discussion is on how corrections works within the law, and we're going to look at some of the laws as they are impacted by. Anyway, so this should be a very brief recap. Hopefully, at this point, you've taken intro to criminal justice already. If not, that's okay. This is something that you're going to see anyway, and you'll learn more about it later. But for those of you who have taken it, this should be a recap. The criminal justice system as a whole is broken down into several different steps. When we talk about it in Intro to Criminal Justice, what we talk about is how uh, there is a process that begins with when a crime is reported. So technically, step zero is a crime is committed, but the system it starts being involved as an overarching piece when a crime is officially reported. This could be by an innocent bystander. This could be by an officer who happened to witness it. Doesn't matter. It starts with the crime being reported, and then it goes through all of these steps. So it's the crime is reported, then there's a preliminary investigation, there's an arrest, there's booking, there's charging, and those early 5 steps really are heavily police. That is the police work. That is when the crime is reported, the individual officers who are in charge of that will look into it. That's why the preliminary investigation is there. They'll make the arrest. They'll book the individual, which is a informal statement of charges and typically holding them in a jail, which we'll talk about again, the difference between jail and prison, which should be second nature by now. Um, but then we also talk about, charging. That's where the official charges are given to an individual. And 6 through 10 is the, if you take in criminal law, it's the law side. It's the judges and court side of it. So there's an initial appearance, usually not before a whole like judge or jury. It's usually an individual, smaller thing to get official charges read to them and things like that. So there's the preliminary hearing in the grand jury, where they decide whether or not it's going to go to trial. Arraignment, which is getting the individual ready for trial, and then there's the trial itself. That part 9 is super complex and there's lots of stuff to the trial, but we're not going to go through that stuff. That's for criminal law. If you're interested in that, I mean, you have to take it anyway, but we go more in detail in that. And then the kind of last part, technically 10 and 11 are both within the legal court section of this, but it's also part of the correction sense. And we're going to talk about that today. So just important to remind you of how the whole system works. Sentencing is where after a trial is completed, the individual is given their official sentence, whatever that may be. We've talked about the different types of punishment that an individual can get. So that's in the sentencing. Obviously, there's an appeal process. In that process, it is possible that either a lawyer or public defender that is working with that potential defendant, they would be working with them, but it's also possible that an appeal process can happen with the correctional officer involved as well, and we'll talk a little bit about that. But then obviously corrections, that is the after sentencing, if an appeal is not granted or whatever it may be, the new sentencing, Now we get into the corrections, which is the how do you complete your sentence? And then obviously release is the end goal of corrections, as we talked about already. Um, again, this is a brief recap. Hopefully, you've taken Intro to Criminal Justice, so this should look familiar. You might have PTSD flashbacks to midterm and or final exam, where I said, here's all the things, list them in their proper order. So if you're one of those students, sorry to bring that back up, but it's important to know how the system operates so that when we talk about these different steps, you understand where in the process. And especially when you go to take other classes like race, crime, and justice, knowing how many areas, how many steps there are where there's contact with the criminal justice system, it's important. It's one of those, it helps us understand where everything is. So, what is the role of corrections as an overarching group, as an overarching career field, as a uh, individual, as a separate section of the criminal justice system, part of it but separate? What are their roles in the courts? And so, really, the big thing that corrections does that is directly impacted with the courts is pre-sentence investigation and the pre-sentence investigation report. And what this is that in the process of the court, again, if you've taken criminal law, you should know this. If not, if you've forgotten, you've taken the class or you haven't taken it yet, that's okay. You'll learn more about it in that class. But after a trial has been completed and a sentence is being considered, uh, there's typically, before that moment, a correctional officer does a pre-sentence investigation. And what they do is they look through the defendant's education, so what's the highest level they have, their employment history and records, so how many jobs have they held, how long, things like that. They look at criminal history. Have they been charged with crimes before? What is the current offense, the present offense? What are they being charged for at this exact moment? Um, and there's an extra impact here, and there's prospect for rehabilitation. Here, this is the chance for the um, corrections officer looking through what they know and what they've learned about the individual. And by the way, these are through interviews with family members, with visiting uh, home life, all these things. This happens usually before a trial as it's going, but it can also happen after a trial, but before the sentencing has been officially given. But the idea is that the officer, the corrections officer, is seeing everything that is in the defendant's life and says, what are the chances that if they go through this program, they will be able to return to normal society as a fully functioning and supportive member of society? What are the prospects of rehabilitation? So, the corrections officer has a decent amount of sway in the sense that this matters. This is important stuff. Um, so the other thing and why they do this, not just because of the prospect for rehabilitation, but personal issues that may impact the court's decision. This covers so many wide-reaching issues, but the idea here is that if a defendant who could be a good candidate for rehabilitation, there's high prospects, with a good outlook, this is great. If there is a personal issue like a history of mental illness, mental health issues, or home life is not stable and any positive growth within the system will be undone upon release, those are things that are going to impact that overall decision. So it's important to note that while when we talk about corrections as an overall thing, and so far in this class we've talked about it as the institution outside and the ways that we follow through with sentencing. This is the first time we're really talking about what they do before that and how that does play a role. So corrections and corrections officers, they hold a lot of power and a lot of input with the potential of release, the potential of rehabilitation, the potential of how serious the official sentence might be. So these are important things to keep in mind. Uh, just wanted to at least, put it forward so that you have this information. Um, so I want to real quickly bring up something related to this, but also is important to note because it's related to us in Pennsylvania. There are some jurisdictions that allow victim impact statements before sentencing is officially done. And victim impact statements they can be letters written by the victim that are sent in or the victim's family. It can be their right to appear before a jury or before the judge and give testimony. It is not required for that in case there is an issue of privacy or security with the offender and the victim. There's a whole lot of stuff with that, but victim impact statements also play a role in the sentencing part. And why I bring that up in relation to this, the role of corrections in the courts, I've been talking about it in this very, it's an important role. Not every jurisdiction, not every state, not every section of state have these same guidelines. Not every state has a pre-sentencing investigation or pre-sentence investigation report. They don't have that time where they ask them to look into it. Some courts just go right into the sentence. Here in Pennsylvania, and specifically here in Western Pennsylvania and Erie itself, we do have pre-sentence investigations and pre-sentence investigation reports. We also in PA allow victim impact statements. So keeping our mind rooted that all the stuff we talk about, obviously most of it is across the board agreed upon in all jurisdictions, but as we come to things that are varied throughout, it's important to remind you what we here in Pennsylvania do. So, anyway, just like I said, another important thing I wanted to bring up is the role of the victim impact statement. That is something that is brought up in the chapter, but I did want to at least address that here. All right, so if you kind of go back uh, technically to, as I said, the personal issues that may impact the court's decision, that is where we're getting into some of these other sentencing things where we talk about severity. And so severity of a sentence relies on two major factors, and usually the second of the major factors is what comes also from that pre-sentence investigation report. So the first major factor that does impact sentencing is the seriousness of the offense. Obviously, a first-time offender who stole a bike is going to be seen potentially less severe of a sentence than someone who has a long history of stealing objects and they recently stole a $13,000 boat. There's a difference between stealing a bike your first time and history of it and you stole a $13,000 boat. That seriousness of the offense is going to play a role in it. We can also it's comparing apples to oranges, but again, theft versus murder. One is a very serious offense, the other one is serious but not as high. So that's one of those big factors that does affect the sentencing process itself. The other piece that comes in, and this is the one that's connected to the correctional officer's pre-sentence investigation, that's the presence of aggravating or mitigating circumstances. And again, if you've taken criminal law, if you've taken intro to criminal justice, if you've taken juvenile justice even, I believe we talk about this. This is a very common thing in the criminal justice system. We talk about it over and over and over and over again. So hopefully, as you finish all these courses and you graduate from us with a degree, you will understand what is aggravating circumstances and mitigating circumstances. You understand concurrent sentences and consecutive sentences. All these terms that show up in all of these classes should be clear and should be something that you understand and you kind of know at a base level. So, aggravating and mitigating circumstances. For those of you that do not know or do not remember, that's okay. I urge you to use what English teachers and people will tell you context clues. So, again, I'm also an English teacher, so aggravating. What does aggravating mean? If someone asks you, what aggravates you? You probably, if you don't know what aggravate means, you might mean, what, give me another word. What makes you angry? What makes you frustrated? So, what bothers you? Aggravating circumstances are circumstances that make the crime worse. They're things that make it larger than it is. It makes the impact, the severity of the sentence a larger situation. Going back to our previous example of the two stealing cases, stealing a bike versus stealing a $13,000 boat, there are aggravating circumstances here. There are circumstances of the price of the object being stolen. There's the fact that there is a history of theft, clearly not been resolved. So those are aggravating circumstances that would make the severity of that original sentence higher. Mitigating circumstances, on the other hand, is the opposite. So aggravating is making it bigger and worse. Mitigating is smaller. So mitigating circumstances are parts and situations that make it less severe of a sentence. If we take our theft example, but change the object from a bike and a boat to comparing someone who steals a bike because they want to steal a bike to a man who steals a loaf of bread to feed his family who's starving. There are mitigating circumstances to the man who stole bread. Number one, bread is severely cheaper compared to a bike. Even with current inflation, it's cheaper than a bike. But we also have those outside external factors that make it less severe of a sentence. We look at it and we go, oh, this is not someone who stole because they want to. This is someone who stole because they had to. And that gets into a deep philosophical, psychological argument debate that we don't need to have. But the idea here is that mitigating circumstances are things that say, all right, this makes this not really that bad of a crime, and we need to do a less severe sentence. So that's important to understand. I actually have it comes right from the textbook, but I wanted to bring it up so that we could look at it and kind of talk about it briefly. So we have circumstances and aggravation. So aggravating factors relating to the crime, whether or not charged or chargeable enhancements include. And so these, again, this is right from the textbook. So crime involved great violence, great bodily harm, threat of great bodily harm, or other acts disclosing a high degree of cruelty, viciousness, or callousness. If the crime is really violent, it's going to be treated more severely. Defendant was armed with or used a weapon at the time. Victim was particularly vulnerable. Defendant induced others to participate. Like, these are all different factors that can play a role in making a sentence more severe because the crime was more severe than a similar crime that did not have these factors. So aggravating factors that are directly related to the defendant, so not to the crime itself, but to the individual who committed it. They engaged in violent conduct that indicates serious danger to society, prior convictions, I mentioned previously, if they were on probation, mandatory supervision, post-release community supervision, or parole when the crime was committed, which we will come back to later when we talk about violation of parole and probation. This is a big issue. And then prior performance on probation, if they have a history of not completing it well, that's going to be an aggravating factor. So in general, like I said, it tends to add more weight, more gravitas to the actual crime itself, and so that means that it's usually a harsher penalty. Whereas mitigation, as I said previously, is lessening it. So relating to a crime was a passive participant or played a minor role. So, the getaway driver in a bank heist, they're not the key person unless they're the ones that planned it. But typically, victim was an initiator of, willing participant in, or aggressor of the incident. So, defense, things like that. Crime was committed because of unusual circumstances, uh, kind of bringing up the stealing bread situation. Really, like I said, all of these situations are to make it less severe, to understand that there's forces that made it not. And so, again, related to the defendant itself, no prior record, uh, suffering from mental or physical condition. They voluntarily acknowledge wrongdoing before their arrest or very early, which we talk about in criminal law. Um, Ineligible for probation, but for that ineligibility would have been granted probation. Like, there are plenty of potential mitigating factors that would make a individual defendant less culpable for it, or rather, uh, have a lesser sentence. And so, understanding that those kinds of issues, those kinds of circumstances can lead to a more severe or a less severe sentence means that we also need to discuss what the type of sentences are. And I don't mean what types of things can you get sentenced, because we discussed that previously with the different types, you know, prison, jail, uh, home arrest, electronic monitoring. We talked about all those things. But what I mean is concurrent sentences versus consecutive. And I will tell you right now, hint, hint, nudge, nudge, this is a question on the quiz. Something that, if you are planning to work in the criminal justice system, whether you're going to work as a police officer, as a lawyer, corrections officer, you're going to be support individual, whatever it may be, if you are working at any point that is involved with sentencing, something you should know is the difference between concurrent sentences and consecutive. And even if you just watch court cases because you're interested, this is something hopefully that's useful. So, if someone is charged with multiple counts of a crime, or multiple crimes as well, how do you deal with that? And so, sometimes we may see for truly heinous crimes like mass murder, sometimes there are consecutive life sentences and things like that, which is redundant and not really needed, but it's to kind of put a measurable seriousness to the crime. But again, that's a different issue. Consecutive sentences means that once you complete one sentence, the next one begins. So if you're charged with 5 counts of robbery and you get for each count a 3-year stay in prison to be completed consecutively, that means 6 counts, 3 years each. That's 18 total years you have to spend in prison. So you do your first 3-year sentence, then you have to do your second 3-year sentence, and your third year, you do it that way. Concurrent sentences, same situation. You are charged with 6 counts of robbery, and it's to be 3-year sentence each, but you're going to do it concurrently. That means that you will have to serve 3 years of prison. The idea is that concurrent is that they are happening at the same time. So usually when you see concurrent sentences, there tends to be a range of crimes and a range of sentence length. So it might be a 2 year here and a 10 year here. If you serve them concurrently, the 2 year sentence, when it ends, that sentence is finished. You are done from that one. You're free from that one. But you still have that 10 year sentence. Well, now you actually have eight because you already served three. So, to explain it redundantly but hopefully clearly, concurrent means that they are all happening at the same time. Consecutive means they happen one after another. So when we talk about sentence length and when you take criminal law, you look at some cases, they talk about sentencing, whether it's concurrent or consecutive. These are important things. So again, like I said, we've talked about types of sentences, but we're going to go over them again just because it's important. This is a large part of the system, a large part of what we talk about. So it's important to bring this up as much as possible to hopefully it fits. So the different types of sentences that we have, this is not in any one order. I actually took this order straight from the textbook to make it easier. So if you're one of those people that learn really well by reading the textbook and listening to the lecture kind of in the background and connecting things together, you'll be able to be like, oh yeah, this is the exact order. If you're not, that's okay. So we'll start right off the bat with the death penalty. This is the most severe sentence in the United States. This is one of those large ethical questions and debates people have all the time, whether or not it's okay to take the life of an individual, whether or not they did anything. And what I will tell you right now, the only crime recognized at the federal level that is worthy of the death penalty is murder. Everything else is life imprisonment at the very least for the worst type of sentence. So the death penalty is reserved for the most heinous crime, as it's phrased, and that is murder, taking of a life. As you may or may not know, not every state has the death penalty. Several of them have outlawed it, some of them still have it, some of them have gone back and brought it back now. This is where I say PA is a weird situation right now. In Pennsylvania, the death penalty is legal. However, former Governor Tom Wolf, I believe 2016, I'd have to double check the years, but did a moratorium on the death penalty. He would not sign any official document putting forward the death penalty for any individual on death row. So essentially, they were living life in prison, just on death row, and the chance that a governor would pass and approve of these essentially put a stay of execution across the board. Our current governor has also recently stated, I believe, like end of April, they had an official statement. I saw it on the official PA.gov specifically for the governor, but they said that their plan is during their entire term, they are not going to sign any death penalty as well. So they are also going to urge our state government to get rid of the death penalty. So whether you're for it or against it, it's important to know that we in Pennsylvania, we are in this current moment where the law is there. It says, yes, death penalty is possible, but the individual to make that final call, the lieutenant governor of the state, is not making those calls because they're trying to get rid of the death penalty. So we're in this weird limbo state. So all I can say is keep watching. Obviously, this won't happen during this class. It's something that takes years and years of working and lobbying and putting laws forward. So in this class right now, we will not see it, but hopefully if you are interested in this stuff and you plan to be in this career, you will see some kind of further discussion on the death penalty in years to come. But anyway, that's brief about the death penalty. Incarceration is another type of sentence, and I already mentioned, there is that life in prison, which death row, when there's not death, is essentially life imprisonment. It's incarceration for the entirety of an individual's life. So that's important to note. If we've discussed several times before, not if, we have. Incarceration is just the holding of an individual where they lose some of their liberties, the right to freedom and stuff of that nature, but they are held by the government or whatever governing body with the entire goal of preventing them from committing. So what's important here and what we need to talk about and why I'm emphasizing this, even though I really don't need to, is that there are two types of facilities for incarceration. There are prisons and there are jails. And when you type in correctional facility in just about anything, autocorrect wants you to choose jail or prison. The issue with that is, while that term is used synonymously in everyday language, a jail is a prison is a jail. Within the system itself, that is not true. And we've talked about this before. This is one of those things that I think we even talked about on like day one of Intro to Criminal Justice. There is a difference between a jail and a prison. Hopefully, this is just a reminder for most of you, but if not, remember, jails are local level, they are short-term stays, and they are not meant to be the end-all, be-all place for an individual to be held past a year. It really is less than a year sentence. Prisons are run at the larger level, typically the state level or the federal level, as we talked about as well. And these are the facilities that offer so many different options for the incarcerated individuals. The goal is rehabilitation. They have the ability to offer these programs. Maybe not all of the programs in one place, but that's the kind of idea, that a prison is a larger facility designed to have more availability and more services for the individual. Jail is temporary. All right. So moving on from that, a lot of these, again, are going over things we've already talked about. Probation, that is where instead of spending time in prison, you are released back into society, essentially usually to your own house. You're not under house arrest, you're allowed to leave, but there are rules that you have to follow, strict rules. Most of them are like no alcohol, no engaging with potential criminal individuals, no doing drugs, and there is a level of check-in. And this is where a probation officer will be involved with them. There's correctional officers, there's probation. Their job is to check in on individual clients and make sure that they are doing what they're supposed to. Obviously, if they violate one of the rules of their probation, they can be subject to incarceration. The idea is probation is the alternative. But, and again, if you take an Intro to Criminal Justice, all these should look familiar because we talk about them in there too. Intensive supervision probation. This is exactly what it sounds like. If you know what probation is, this is just probation on steroids. This is, you are given a very strict list of things that you can and can't do. But the biggest difference is its intensive supervision. We're talking daily check-in, multiple daily check-in. Like, pretty much the idea is that if you have to go to the bathroom, your probation officer probably knows about it. That's how intense it's are. Obviously, I'm joking about this, but at the same time, the difference between regular probation and intensive supervision probation is that drastic. Probation, realistically, might be every 2, every 3 days, maybe even once a week checking. Intensive is more than once a day. They are making sure that you are doing everything you need to do. And usually it's for people that have a tendency to re-offend and break their and violate their probation. We talked about before boot camps. Again, this is just a military structure idea where you. I almost said a different thing that is equally connected to this, but has nothing to do with criminal justice. Boot camp, the idea is that they beat the bad out of you. They are doing rigorous military training, and the goal is that it will make you no longer commit crime. A lot of the data from that shows that it doesn't really work if an individual is already prone to military structure and would thrive in that situation. Yeah, they're going to show great growth, but if they don't respond well to that kind of stuff, boot camp doesn't help. There's no data that says, "Oh yeah, this works perfectly." Statistically speaking, it's kind of a bust, but it is still a house arrest and electronic monitoring. This is the cliche thing you see on all the cop drama shows where an individual is essentially confined to their home or a radius around their house, and they have some kind of monitoring, usually that electronic ankle monitoring stuff. Um, but the idea is that if you leave that set area, the monitor sends a signal, and individuals are sent and dispatched, and that would be violating your house arrest, and you would then be incarcerated. We have to talk about fines and restitution. Reminder that restitution is payment to the victim, whereas fines are payments to the government. That's the real big distinction between the two of them. But also a quick reminder, we talked about before, day fines. Because remember that there are flat rate fines, but there are also the possibility of day fines, which are adjusted to what your daily income. And then obviously, one of the last ones, community service. Not usually just its own thing unless it's a very minor offense and a first time minor offense at that. But yeah, community service is a alternative sentence, but we also see community service tends to be a combined kind of sentence with several of the other kinds. So you might be on intensive supervision, probation, or probation, and you might also have to do community service. You might have fines in community service, restitution community service. All these are possibilities, but yeah, it's pretty straightforward. It's community service. The last one, and this one has seen not as much use, but still there, and that's public shaming, also known as scarlet letter punishment. We talked about this before. Its other name, the scarlet letter punishment, comes from the literary work, the Scarlet Letter, where, spoiler alert for a book that is several decades old, a man and a woman who are not married to each other commit adultery together, and the woman is punished for this, and the man isn't for many reasons. Go read the book if you're interested in it. But she is forced to wear a scarlet A on her chest, on her clothing, and she always has to wear it as a sign that she is an adulterer. She committed adultery, and so that's where Scarlet Letter comes from. But the idea is public shaming. You are publicly humiliated and ridiculed for the crime you commit, with the idea that that public shaming will make you never want to do it. Does it work? Debatable, hence why it's not really used as much. So, in talking about sentencing, we talked about the different types, but something that is related to this, but not a type of sentence, is asset forfeiture. And the text has an entire little part just on asset forfeiture. But really, all that I want you to, understand and know, because all the information is important, but the key point of asset forfeiture is that when an individual has some kind of asset or monetary gain or something from illegal activity, and you are arrested for said activity, the assets that were used or ill-gotten gains from are subject to be forfeited and taken by the government. They have the jurisdiction to do that and to seize the property, and assets that were used in criminal enterprise. So the idea here, the goal is crime doesn't really pay. If you get away with crime, it pays, but the moment you get caught, everything you gain from it, all this massive wealth and the cars and everything, gone. Government takes it because they have a right to it. That's really what asset forfeiture comes down to. Um, it's just taking objects that were used or gained through illegal purposes. So if you're, you know, not a criminal, you don't have to worry about asset forfeiture unless you are tax evasion. But that's also fine. Anyway, um, we need to talk about appeals. I mentioned it earlier, so in case you don't remember, appeals, that is claiming that a procedural or legal error was made. And so really what that means is that throughout the process of your trial, something wasn't fair, something wasn't right, whether it be, as I said, a procedural error, which means that some right or some part of the component of the trial was not followed properly. If there was some issue like that, that is an error, a procedural error. A legal error is a lot harder to prove, and again, these are things we talk about a lot more in criminal law. But legal errors are where laws aren't followed correctly, or laws are incorrectly cited or used inappropriately, or essentially the idea is that the law that is being cited or used is wrong. So that's why it's a harder one to prove. The procedural one is easier, uh, relatively easier, but it's important to know that in the appeal process, there are two outcomes. And breaking it down, again, the text goes more into detail, but the basics is that they either confirm the lower court's ruling or they confirm the appellate's, which is the appealer. There. And so really what this means is that if they confirm the lower court's ruling, this means that they say, unfortunately, your appeal is not accurate. We see that the lower court was correct in their ruling, and we confirmed that, and your sentence is to be completed as such. When they confirm an appellate's claim, that's different. That's where they confirm that there is a substantial issue with that particular outcome. But that doesn't mean that they get off scot-free. What happens is it is sent back to the lower courts for essentially a retrial so that that failure or that error that was made is not made again. So how this does work out in some senses, not sentences, but how this plays out in some sentences is that some cases realize if the appellate court says, you know what, there is an issue of evidence in the way it's ruled that can't be used. If then the state goes, well, we don't really have a case, then yeah, you would get off. There would not be a retrial, and they would withdraw their claim. That would end it. But if there was a legitimate claim and it got retried and the state said, you know, we do still have plenty of evidence to prove it, you would have to go through that process again, and you would potentially have another or worse sentence. And so, again, understanding how this is related at all to, as I said, corrections, and that's the point of this is that in this process, knowing the types of sentences and the fact that sentences can be appealed means that you understand that not every sentence is, not every inmate is the same, not every individual you work with, not every defendant you work with is going to be the same. If they appeal it and this is their second time for that crime because they appealed their first, it might be a very different situation. But how it all comes back and how we get here is sentencing. So There are three main lengths of sentences. There are indeterminate, determinate, and mandatory. Indeterminate literally means there's not a set. It is not determinate. Determinate means a fixed set. But indeterminate, there's no set time, but it really is more dependent on the conduct and behavior of the individual while they're incarcerated. The parole board is the big part for indeterminate sentence. These are where individuals on the parole board will review your request for parole so you can leave prison based off of your good behavior. Those are indeterminate sentences. Determinate sentences are fixed time lengths where you usually have to go for this certain amount of time, at least minimum. There's other stuff with it, but there is the idea that there's a set time. You have to complete the sentence. There are exceptions for good behavior and things of that nature. But how this differs from indeterminate is that typically determinate sentences do not get access to a parole board. You are meant to complete your entire sentence. If the warden and things of that nature in a particular facility sees that you've had great improvement in best behavior and you could potentially get less time, they might make an appeal to the parole board to lessen your sentence. It's not you going before the board, it's that decision being made. That's the term. Mandatory sentence is they set a minimum time with which you have to be there. So it's like determinate, but like indeterminate, it kind of is going for whatever. So the idea is that there's a mandatory set time for like 10 years. You have to be at least 10 years in prison. But after that point, if you're not ready for release, you stay in prison. You stay incarcerated until you're ready. Mandatory sentences always go for that minimum. And the idea is that when you are ready, you can be released. This is usually, mandatory sentences are usually for repeat offenders, people who have committed a crime, potentially violated parole, things of that nature, because they already know the system. If they've made that mistake, maybe they were on an indeterminate sentence and got out pretty quickly, and now you know you're going to have to complete at least a minimum of 10 years. That all right. So this is going to be the last kind of thing that we talk about today. And this is where we get into the laws that have an impact on corrections itself. So we need to talk about the Sentence Reform Act, or rather the Sentencing Reform Act of 1984. The whole idea of this is to establish fairness in federal sentencing practices. Like all these things, all these bullet points, these are all things that the Sentencing Reform Act of 1984 put forward. Really, before we get into that, the whole point was this is a response to congressional concerns about fairness in federal sentencing practices. At this point, while yes, there was still a central unit for, corrections, I couldn't think of the word. That was for facilities itself, but for the courts, there wasn't really a whole set of rules. There were previous sentences, but it was very much up to the judge's discretion. They were given almost free rein to determine how long someone would be incarcerated or how long someone would have a certain sentence. And that was beginning to be a problem. So the idea with Congress was that there is some issue that there are prisoners who, and one of the examples they used at that time was, if you're in Race, Crime, and Justice, you already know where we're going, but the difference between African Americans and white Americans being charged for drug possession. African Americans were getting way more severe punishments than white individuals for literally the same crime. And so Congress was like, this is a problem. We need to fix it. And so the goal was the Sentencing Reform Act of 1984. It didn't go into effect until 1987, but the idea was to establish fairness in federal sentencing practices, create the U.S. Sentencing Commission, which was a group that oversaw this. It altered judges' sentencing discretion, so no longer could they just kind of have free reign. They had certain sets that they had to keep within. It altered the probation officer's preparation of pre-sentence investigation reports. Now they actually have certain things they have to go and do. It's not just a. I talked to this one dude outside. He said he was bad. Boom, done. Actually, made sure that these things were done correctly, sufficiently, and gave good information. It also altered officers, particularly probation officers, overall role in the sentencing process. What this did, and this is the next point, it placed officers in a more adversarial environment in the court. What this meant is that they actually were then put in front of attorneys. They were at the mercy of lawyers. So now attorneys could dispute facts, question guideline calculations, and object to information in those reports. No longer was it, here's the pre-sentence investigation report. I'm behind closed doors. I don't have to worry about it. Now it was out front in public, and a defense lawyer could go, whoa, 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 whoa. That's so that changed that role. That changed how that looked. The other thing they did is and I noticed I put quotations around replaced. They replaced the term parole with supervised release. That's a lesser thing because we still use the term parole within the larger criminal justice community. More or less, what it really did was focus on how we phrase things because the power of words. So supervised release was the idea that you're not on parole. You are released from prison, but you are being supervised. There is still parole, but it's so. The next thing I want to look at is actually a web page. I've made it available, but this is right from our own Pennsylvania government. So in regards to keeping things related to us in this area, we're going to look at Title 61 of the Commonwealth of Pennsylvania. So that's the end of the slideshow. So if you've been following along with the slideshow, but you'll notice here under week 5, you'll see Title 61 prisons and parole. So this is a very boring web page. It is not exciting, and it is full of a lot of what we like to call legalese. If you've taken criminal law, this should look somewhat familiar. We didn't look at Title 61, but we did look at some of the legalese of the state of Pennsylvania. So we're going to look at some of that now. So this entire section is all about prisons and parole. So here in Pennsylvania, our main focus, again, is not on jails, but on prisons, because jails are short-term holdings, whereas prisons are long-term with the goal of rehabilitation. And so we're going to look at just a couple of these really to get a clear idea of what kind of laws are out there, what kind of oversight there is, because that's something we need to talk about. And so if you've not ever looked at this stuff or read this before, let's walk through it. So all this is Title 61 content. It's broken down into different parts. General provisions gives you literally definitions of things that you should know about prisons and parole and this kind of stuff. So if you're not totally sure, there's an entire subsection on it. But anyway, we're just going to dive right into Part 2 is correctional institutions. And we're going to look at Chapter 11, General Administration, Subchapter A, Penal Operations and Procedures, and we're going to specifically look at subsection 105 and 106, the powers and duties of the department and the powers of police officers. And so how this website works literally is you click on the individual subsection, it tells you this is what it's about, and it'll open up a separate page that gives you the in-depth detail. The other part of this is if you really are a sadist, all of them, every single one that's mentioned is below the clickable list. So if you really want to, fill your eyes and stare at this one page the whole time, you can. but if you're like me and you like having separate pages, it's easy. So, here in Pennsylvania, the powers and duties of the Department of Corrections and General. The general rule, the department shall have the power and its duty shall be to establish standards for county correctional institutions, including but not limited to standards for physical facilities and standards for correctional programs of treatment, education, and rehabilitation of inmates. So right there, we already have in black and white that in the state of Pennsylvania, according to the Pennsylvania General Assembly, according to our bylaws, our rules, that the Department of Corrections, they will establish standards, and those standards are for all, not just facilities, but programs of treatment, education, and rehabilitation. So we already see treatment and education, which thinking about last week and the types of sentencing and those extra factors that play into it. Education's a big part, so is treatment, and then obviously rehabilitation is the goal. The other general rule or guideline is that they need to inspect county correctional institutions and to classify them in accordance with standards adopted under paragraph 1 as eligible to receive inmates sentenced to maximum terms of 6 months or more, but less than 5 years. So here in PA, that's our standard. Rules and regulations, the department may prescribe, adopt, promulgate, and enforce rules and regulations in order to administer the provisions of this section and the date. And then there's a 2010 amendment, Act 95, added section 1105, retroactive to November 9th, 2009. So this is all the fun legalese. If you have any desire to become a lawyer or a judge, this is what you're going to spend a lot of time thinking and looking about. If you have absolutely no interest or this has definitely turned you away from wanting to be a lawyer or a judge, I'm sorry. Welcome to Legalese. I'm not going to do too much of the in-depth talking about these. That's for criminal law, but I figured at least give you a couple examples related to correction. So subsection 1106, powers of peace officers, a chief administrator, deputy superintendent, or corrections officer of a state correctional facility may exercise the powers of a peace officer in the performance of that individual's duties, generally in guarding, protecting, and delivering inmates, protecting the property of the department, and capturing and returning inmates that may have escaped within the immediate area of a state correctional facility or mode of transport. For the purposes of this section, the immediate area of a state correctional facility or mode of transport shall encompass the curtilage up to and including 1/2 of 1 mile. So, what this is saying, straightforward, is that a peace officer or anyone who works within a state correctional facility as an officer, no matter their role, whether it's deputy superintendent, chief administrator, or just a corrections officer, they may exercise the powers of a general peace officer as long as it is guarding, protecting, and delivering inmates, protecting property of the department, and capturing and returning inmates that may have escaped. Peace officers are also essentially beat cops, just to kind of give a general idea. So yeah, obviously we can look more at, subchapter B is all about inmate transfers. So, specific pieces, like we might look at the law enforcement use of county correctional institutions, which just says sheriffs, constables, members of the Pennsylvania State Police, and other persons authorized by the laws of the Commonwealth to make arrests shall have the use for a period not to exceed 48 hours of borough and township lockup and county correctional institutions for the detention of persons arrested so they can be disposed of according to law if found necessary by the officer. Basically, this means that in a pinch, any kind of law enforcement member that is with an individual, they can, within reason, they are allowed to hold an individual at a facility that is not set for them no longer than 48 hours, essentially just to make sure that you have proper transportation, that kind of thing. So yeah, really, if you are interested, and like I said, I made sure that this link was available in our folder. If you're interested in some of the very specific rules and guidelines, by all means, I've identified several uh, chapters, subchapters, and subsections that are worth looking into if you're interested. Um, but some of the other highlights I just want to briefly look at, maybe not going in depth, but Chapter 17, County Correctional Institutions. County Jail Oversight Boards. There's an oversight board for county jail. And essentially, this means that there are additional levels of checks and balances. Individuals that make sure that things are running correctly, properly, and above board. Across, as you look at this, if you are feeling overwhelmed by looking at this, that is both a good and a bad thing. The bad thing is, I would hope you're not feeling overwhelmed just by looking at this. I'm not making you read all of these. Even if you become an officer and you work within this field, you become a lawyer, nobody memorizes all of them. These are just readily accessible. You have a general idea of what is and is not allowed, and you can always look it up. It is public information. It is legal government information, so it has to be out. But the good side to feeling overwhelmed from this means that there's a lot of specific laws looking at just prisons, and then as we get further down, you'll see actual parole stuff. So we talk about inmate labor and confinement. We talk about medical services. There's one I really put forward because I want you to think about it. Chapter 31, inmate labor. What kind of work are they going to do, and what kind of rules are there for this? Obviously, there are other things like medical services, which is chapter 33 is just medical services, but your focus should be subsection 3303, 3307, 3304, that kind of thing. So, if you just keep scrolling through motivational boot camp, so we do have rules for boot camps here in Pennsylvania. We have state drug treatment programs. Again, as I mentioned earlier, execution, procedure, and method. Here in the state of Pennsylvania, our official method of execution is lethal injection. Um, but again, as I stated earlier, this is currently in a weird flux position. Um, we have recidivism risk reduction incentive, uh, non-narcotic medication-assisted substance abuse treatment, community corrections facilities, safe community reentry, which is what we talked about before, the reentry programs that most facilities offer, community correction centers and facilities, miscellaneous provisions, which I'm going to draw your attention to one thing in particular, just because it's related to our first what if scenario. Chapter 59, miscellaneous provisions, subsection 5905, healthy birth for incarcerated women. We have a specific piece on this. We have specific laws relating to restraint of pregnant prisoners, uh, duties of a correctional institution regarding someone who's pregnant, all about restraint, the annual reports, which includes also definitions of things that are mentioned above. If you think about the what if scenario and you weren't sure what kind of laws were already in place, this shows you that there is a decent amount of information, a decent amount of laws and oversight to make sure that everything is done effectively, correctly, and above the board legally. So, again, I really think it's just important to know Pennsylvania Board of Probation and Parole, because we did talk about it Subchapter C is all the powers and duties that they have. So if you're interested, that is a good section to read as well. And then Chapter 63, County Probation Officers, Firearm Education and Training. It's a mandatory thing. So if you are thinking about being a probation officer, this is something that is part of that requirement. Like I said, I don't want to go through all of this. I could spend hours going through several of these and talking about them in depth with you all, but that would be for a criminal law class. Those who took it are rolling your eyes, I'm sure, like, oh God, not again. The idea here and the whole reason why I wanted to show this to you and make it available is so that you understand that there are things in place to make sure that things are safe and done correctly. Which leads me into our what if scenario 2 as well as our discussion board for this. Um, let's look at the discussion board real quick before we dive into it. So as usual, the folder, as I noted last week, I moved quiz 3 to this week just because I wanted a little more content on the quiz that would help for the long term for that final exam. It is coming up in week 8. But so we have quiz 3 is the last thing in this folder. What if scenario 2, we'll look at in a second, and then discussion board 4. So the notes are officially done. This is just me talking about some of the pieces that are coming up, so you don't really have to focus as much. You can click off the video now, and you're not missing anything. It's just me talking about these. But so this week for discussion, examine the amount of oversight and policy in place for correctional facilities that we've discussed, and consider what we've talked about so far throughout the class. So, drawing your attention to all this. With everything we know, I want you to consider this one question. Why are there issues with corruption within the field of correction? And I know just right off the bat, it seems like an easy and obvious answer because corruption is everywhere. And that's fair. But I want you to expand and explore a little bit more than just corruption. What are some of the long-reaching consequences of these situations? With corruption within corrections, what kind of consequences are there? And not just for the individual who commits those crimes, but what does it do for the overall system, for the facility that was behind it, or all these other things? What are these consequences that happen from people being dumb, essentially? Shouldn't the laws in place prevent them from happening? This is kind of one of those tongue-in-cheek questions because we talk about it. One of the goals of having laws in place, one of the goals of prison time is to prevent you from committing a crime. It's to deter you because you don't want to pay for it. But there's corruption within corrections. People who know that these are laws they're breaking, and yet they still do it. Shouldn't the laws prevent them from that happening? Isn't the point of the law to deter individuals from committing a crime? So, knowing that, the main question I want you to tackle with this week really is, why is there an issue of corruption within the field of correction? Why is there corruption? So to understand this issue, I'm not going to make you read any one particular case, but I'm encouraging you to look at real examples of recent scandals within correction. So you can Google search correctional facility scandal, and you can come up with a very recent and slightly older issues of corruption within the field. There's several possible hits and things that you can find that would be worth reading. If you have no idea where to start, and one that I highly recommend because it's related to here in Pennsylvania. One case I strongly suggest looking into is the Kids for Cash scandal. That happened here in Keystone State. It happened in Luzerne County over in the eastern part of Pennsylvania. If you've never heard of the Cash for Kids scandal or Kids for Cash scandal, it's something. It is not an easy topic. It is kind of sad, but obviously it's a good example of issues of corruption within corruption because it's juvenile detention facilities and judges. That's what this is all, what that stands for. So look at some real world examples. If you want more examples like this for cash, if you want me to give you a couple of them, feel free to reach out to me. I'll be glad to post links to several different potential ones for anyone who's interested. But I really want to give you the chance to explore. I want you to find some kind of real world case and dig into why this is a problem and what kind of impact it has. So I'm leaving the door open. So hopefully you kind of dig into something a little bit deeper. Obviously, I don't have anything outside of our normal, keep a fair discussion and things like that. But I'm looking forward to this because this is going to be interesting to see what kind of cases and stands. Yeah. So the what if scenario two, I already have the PDF, so I'm just going to pull it up here. So our discussion this week is related to laws. So last week we talked about pregnant woman and the rules regarding, transportation and things like that. So is an inmate's life worth breaking policy? And so the main question, that is the question that you are answering in this what if. Yes, there are other questions within, but they're all related to the same thing. So I don't expect you to answer all the questions they're asking. So is an inmate's life worth breaking policy? Should an officer be punished for doing what comes naturally when seeing someone in peril of death? So our situation talks about an individual officer. Again, remember, you come from a website. I do give credit, corrections one training scenarios. The idea with this one is that an officer leaves, breaks the protocol for security to save a inmate who has attempted suicide. So slight trigger warning, anyone who is sensitive about the subject of suicide, the point is not to focus on that, but the point is to understand, is it okay to break protocol to save a life? Very morally gray area, but so the situation is given. And then obviously my additional questions that I want you to think about outside of that is, do inmates while in custody of the facility still have rights? Kind of a trick question because I hope you would know that answer by now. What kind of exceptions or rules would address the issue of imminent harm or loss of life for an inmate? How liable or responsible is the correctional facility if the inmate had succeeded? How liable or responsible would the officer be if the inmate had succeeded? And then to kind of bring it all to a real in-depth thought, are there any potential issues in allowing a break in security protocol to save an inmate who seems to be trying to take their life? Please note I phrased that very carefully, um, drawing your attention to, are there any issues that could happen if you break protocol to save an inmate who seems to be trying to take it? All right, that's what I got for you. I know this is probably going to be a slightly long video. Apologies now, but I wanted to make sure that we talked about everything we needed to and looked at everything we needed. If you have any questions, feel free to reach out to me. Uh, email is the best way to get a hold of me. And as I stated last week as well, make sure that all your grades for the previous week are graded and returned to you by Wednesday. So look forward to those. You can get the feedback from my stuff from week 4 on Wednesday. But that's it for now. Have a good day, night, evening, fourth meal, weekend, whatever day you are watching this. Have a good time, and I'll see you all in the next video. Bye for now.